Good day. This week's tutorial focuses on the legal consequences of irregularities in required processes within an HOA or a sectional title scheme. Stated otherwise, we will be looking at the effects from a legal perspective of a failure of a community scheme such as a sectional title scheme or a homeowners association to comply with the procedural requirements of an applicable act such as the Sectional Titles Act or of its governance documents such as its rules or articles. This tutorial is designed primarily for owners who feel that their scheme executives do not do things by the book, but I think it will also be of interest to managing agents and trustees. This is also an issue that has come up recently in the discussion forum within Paddocks Club in the context of a sectional title scheme. As an overview, just to explain that we're going to have a quick look at the provisions catering for irregularities, at apparent authority, at the fact that only a wronged party can take action, at the majority rule principle, at the requirement for material prejudice, and at the requirement for reasonably swift action. Okay, the Act and governance documents set various requirements, and when you read them, generally an imperative such as must or shall indicates a legal obligation, a requirement. But the question is, does non-compliance with such a requirement invalidate the meeting or the action taken? To claim that a procedural requirement is not being complied with, or even to produce proof that that is the case, does not necessarily mean that the decision is invalid or it can be ignored. Often owners, trustees or directors who don't agree with the content of a trustee or director or membership decision will claim that it's invalid and of no effect whatsoever because of some underlying irregularity alleged or proven. Not every irregularity means that the action or decision has no legal effect whatsoever. First, let's look. There are various provisions in governance documents that cater in advance for procedural irregularities. They may specifically say in either the governance documentation of an HOA, the articles or constitution if it's a common law HOA, or the rules of a sectional title scheme, there may be a specific provision that says that the accidental omission to give notice to one or two members, for example, shall not invalidate the proceedings at that meeting. And I've given you an extract from a real set of HOA articles which says exactly that. You'll see it on the screen now. Prescribed Management Rule 54.5 in the sectional title context does the same thing. Inadvertent omission to give notice to any person entitled to notice of a meeting doesn't necessarily invalidate that meeting. So that's the type of provision which you might find. Then there's the question of apparent authority. Now, apparent authority may validate actions taken on the basis of what are, objectively speaking, irregular procedures. So, when the action of an HOA company director or sectional title scheme trustee appears to be authorized, or in general, if such matter appears to an outsider to be regular, and that outsider deals in good faith with the HOA or sectional title scheme, the action taken as a result of that is not affected if it transpires that there was some error in the internal management of the HOA or the scheme. This is a common law principle, but it's also repeated in the sectional title context in Prescribed Management Rule 11. On your screen now, any act performed by the trustees, notwithstanding that it turned out later that there was some procedural irregularity in the appointment or continuance in office of a trustee, remains valid. So look out for that type of provision. It is a general principle that only the wrong party can take action to invalidate an irregular action. So a member of an HOA or owner in the sectional title context must be personally wronged before they can take action on the basis of an irregularity. In other words, the defect must have breached one of that member's personal rights. An example would be a member's right to be notified of meetings or to have his vote counted at general meetings. These are examples of obligations owed directly to a member that could potentially found an action. But if a procedural irregularity is, on the other hand, a breach of the HOA or the scheme's rights, rather than a breach of the rights of any individual, then the individual will not be able to take action to redress the wrong. An example of this situation is where a number of directors or trustees, but less than a quorum, purport to take a decision. Here, the HOA or the sectional title scheme, the body corporate, has in fact been wronged. Not any member, and only the entity can bring an action against the errant executives. There is also a majority rule principle, and what this says is that if a decision that a member wants overturned on the basis of an irregularity can be confirmed or ratified by a simple majority of members in general meeting, then the court will not interfere. And it doesn't actually have to be, they don't have to meet to ratify it. They may all act in a way which makes it absolutely clear that they do ratify it. And on the other hand, that principle doesn't apply when the decision is not within the capacity of the HOA or scheme in the first place. A majority can't ratify a decision that it couldn't have taken in the first instance. In practice, this means that a member's first recourse must always be to the membership. If the majority of the members support the decision or the action which has been irregularly taken, the member is bound. If the majority of the members don't support the questioned decision or action, then the HOA or scheme can take action to overturn it. Any procedural irregularity, in order to found an action, must be material. There must be some material prejudice before an action can be commenced. So it's a general principle that the law doesn't concern itself with trivialities. But of course, what may seem trivial to one person may appear to be very significant to somebody else. A court or other tribunal will always look to see if an irregularity complained of has actually caused material prejudice in the specific circumstances to this particular member. And it will be up to the member concerned to show on a balance of probabilities that he or she has actually suffered loss or detriment to the extent that justifies the action. Let's take two examples. Trustees don't hold the AGM within 4 months of the financial year end, as required in terms of Prescribed Management Rule 51.1. Well, yes, it should be held within that period, but if it's not, what are you going to do? Stop having meetings at all? The fact of the matter is you've got to get on with the scheme. You've got to run it. In the same way, if trustees don't give owners notice of the levy amount within 14 days as required in terms of Prescribed Management Rule 31.3, but in fact do so later, there is no prejudice in actual fact. Yes, you might have got the notice wrong, late on the wrong date, but at the end of the day you got the notice. You knew how much you had to pay, and in the end you paid it, or should have paid it. Action on the basis of a procedural failure must be taken as soon as reasonably possible. You can't simply rely on the fact that there has been a procedural irregularity and not take any action to overturn it within some sort of reasonable period. A member can't simply protest, say, I don't agree with this, and then do nothing in terms of commencing an arbitration or an action, and reserve the right to do that at a later time. The court is not going to entertain an action that has been delayed because it didn't suit the person to bring it earlier. I hope that this has been of assistance. Thank you for watching this Paddocks Club tutorial, and I hope to hear from you in the discussion forum.